Our question for our assignment is Tan Sri Berhad manufacture various kinds of electrical goods for household purpose. After looking at a sample of an electrical stove, Mune, a retailer, ordered 50 stoves from the company. When Mune received the goods, all of them corresponded with the sample. One of the stoves was sold to Bibi. When Bibi first used the stove, it exploded, which is caused a fire breakout in Bibi's kitchen. The kitchen was badly damaged and Bibi and her child suffered a severe burns. The first question is, advise Bibi on her rights against Muneh and Tan Sendirian Berhad. The second question is, can Muneh bring action against Tan Sendirian Berhad? Discuss.
The first one, advise Bibi on her rights against Munir Sendirian Berhad. Issue is Bibi has the rights Munir in respect of guarantees in the supply of goods. Principles, Section 41(2) Consumer Protection Act 1999. Consumer has a right of redress against the supplier in respect of the failure of any goods to comply with a guarantee. Consumer may obtain from the supplier damage for any loss or damage suffered by the consumer, other than loss or damage through a reduction in the value of the goods, which is proved to be a result or consequence of the failure. Case to support. Priest vs. Last, 1903. This case demonstrates the principle if the buyer told the seller the particular purpose which he or she is purchasing the goods, then it is an implied the condition that the goods are reasonable for the purpose. From this case, the buyer who bought a hot water bottle from the seller was a chemist. His wife uses the hot water bottle and then after 5 times, the bottle burst and the wife was scalded. Evidence shows that the bottle was not fit for use as a hot water bottle. The buyer claimed for breach of implies condition of fitness for purpose. The seller stated that the buyer had not made known the purpose for the hot water bottle would be used. However, this was rejected by the court. The court held that the seller has entitled to recover the expenses in the treatment of the buyer's wife injuries. It is because the buyer relied on the seller's judgment and he had in fact used the hot water bottle for the usual purpose. Application. In this case, we assume Bibi bought the stove from Munir in accordance with Munir's description. So, Bibi as consumer has the rights under Section 41(2) to require Munir to remedy the failure within a reasonable time or obtain from Munir damage in compensation for any reduction in the value of stove below the price paid or payable by the Bibi for the stove. Bibi can also claim from Munir for damage for the loss or damage occurred in Bibi's kitchen and the damage to her child, who suffered with severe burn, which proved to be result or consequence of the failure.
The next one is rights against Tan Sri Berhad. The issue is, did Bibi has the rights against Tan Sri Berhad in respect of guarantees in the supply of goods? The principle that have been applied in this issue is the Consumer Protection Act 1999. This act provides for the protection of consumers. It also prohibits misleading and deceptive conduct, false representation, and unfair practice which is capable of leading consumers into error. It also provides for unfair contract terms and for offences in relation to this provision. The Act provides for guarantees in respect of supply of goods and services, and for rights against suppliers and manufacturers in respect of guarantees in the supply of goods and services. The Act further provides for the establishment of the National Consumer Advisory Council, of the Committee on Advertisement, and for the Tribunal for Consumers Claims. The last one is the application. Mooney sold the stove after confirming that it was identical to the sample. Unfortunately, the first time Bibi used the stove, it exploded, causing a fire in the kitchen and severe burns to her child. There was a violation of the implied criteria of ad description of acceptable quality. As a result, Bibi has the right to sue Tanzania Berhad under Section 50 of the Consumer Protection Act. If that particular product fails to meet the implied guarantee, BB have the right to sue for any loss or harm caused directly by the product's failure to perform correctly, as well as for the product's diminished worth. However, BB should be aware that there are two situations in which that will be unable to seek redress from the manufacturer. This includes the situation where the product's quality is not up to grade and the product doesn't match the description because of a flaw or representation made by someone other than the manufacturer, or because of circumstances beyond the producer's control.
Okay, can Munir bring action against Tanzania Berhad and discuss? From this, we can see that issue from the Munir bring action against Tanzania Berhad can we discuss as whether Munir as the seller can take action toward Tanzania Berhad and as the manufacturer due to contract of sale by sample. And we can see that when Munir, a retailer, ordered 50 stove from the company, and Munir received the goods, and Munir sold it to the BB, and when BB used the stove, it exploded, and which caused a fire breakout in BB's kitchen. The kitchen was damaged, and BB and her children suffered severe burns.
For legal principles, under Section 17, sale by the sample is which means a contract of sale is a contract for sale. By example, where is a term in the contract expressed or implied to that effect. Implied condition in the case of a contract for sale by sample were listed below. This case can be supported with case of Drummond v. Van Eagle. In this case, Tan owes Munir a duty of care because it was their responsibility to inspect the goods before it was sold, and such duty of care is non-delegable to Tan Sendiri Yang Berhad, who manufactured in the premise. Bibi, who was customer of Munir, had incurred damage and several burns. When Bibi first used the stove, Munir had conducted a thorough examination, but the flaw was not apparent during that examination. As a result, Munir has the authority to take action against Tan Sendiri Yang Berhad for a breach of the terms of contract by sample under Sales of Goods Section 35.
In conclusion, Munir can bring action against Tan Sendiri Berhad because we can see from the simple under Section 17 that sale by the sample which means a contract of sale is a contract for sale by sample where there is a term in the contract expressed or implied to the effect. Besides, Munir as the seller can bring action towards the manufacturer Tan Sendiri Berhad as the contract has been repudiated.